Well, thank you everyone for joining us today. I really appreciate this opportunity, and I'm really I don't know that excited is probably the right word, but as we wait for a few stragglers to join us, let me tell you a little bit about me and why things like this excite me, I guess. My name is Carolyn St. Pierre. I'm what I like to call a recovering attorney. I practiced employment law for a little over 8 years directly, then went into the consulting world and initially worked with very large companies. And my brother owns a small business out of Colorado Springs, and he was always calling me with questions. You know, what do I do about this employee? What do I do about this? And, you know, we got a notice about this, and how do I respond to my unemployment insurance? And so it was at some point, starting to have a family and not wanting to live on the road, that I started my own business. And so today we sit with 9 employees, Symmetry Consulting, and we help. Our aim has been, big businesses have expensive pockets for expensive consultants and lawyers and all of that on their teams, and small businesses, like most of you, don't have that. And so that's what we built. And I'm really excited about what we do, but you know, as an attorney, this is what's interesting to me. When we look at exemption status, it's you know, forever it used to be that, and my brother's company, I'll reference him, was no exception. They allowed, you know, they would say to an employee, if you want hourly, we'll pay you hourly, but you don't get any paid time off and you don't get benefits. But if you want to work, if you want to be exempt, I'll give you, you can earn PTO, and we'll give you, you know, health benefits and dental benefits and a 401k and all these great things. And that was the case at a lot of large companies. And unfortunately, we're going to talk about this a lot today. We can blame the administration for a lot of things in Washington, D.C., but the reality is that a lot of this comes out of litigation. This litigation bubbles up from, it really bubbles up from employees and, oh, somebody's not, I don't know, sorry about that. I got a loud beeps in my ear. Anyway, so all of this bubbles up from litigation. And the litigation all derives from our good friend, the internet. I used to call it Google, but reality is not everybody uses Google. And employees are just becoming smarter. And so this was all initially set up so that when we look at the law, employees have the ability to sue their employer at any time for any reason. And they often can find a plaintiff's attorney that will represent them for free. So the challenge is, we're looking at, the American Bar Association put out a statistic that suing your employer or employment-based litigation has increased 700% over the last 5 years. That's pretty substantial. So when we look at things like this, people are reporting to the EEOC, the Colorado Department of Labor. They're reporting all over the to people, plaintiff's attorney, and they're chasing you for money. And so you have to be very aware that that's what it's at stake for you. And so it's your decision ultimately to do that, and we'll go through a lot of that today as we work our way through. So all of this started, believe it or not, under, it's called the Fair Labor Standards Act of 1938. A lot of people call it FLSA. Or if you're me, and maybe I have a bit of dyslexia, but I just like the sound of FSLA better. It just flows off my tongue a little bit better. But you'll find people interchange the L and the S all the time. This act, if you know, obviously by the date, it's a living, breathing act that is consistently changing, growing, but initially set up our 40-hour work week. It established a national minimum wage for the first time. Before, we had people who would pay, you know, nickels for a day's work. And it set forth the idea of a living wage, which, whether or not you believe in it, that was the idea behind it. And it guaranteed that when someone worked over 40 hours, it gave them time and a half. But the biggest piece of this legislation that went through in 1938 was it took kids out of the workplace. Because if you recall, post-depression, kids were dropping out of school to help make money so that, you know, mom had, you know, more than just a leaf of cabbage and a bowl of boiling water. So this is where it started. Like I said, this is an ongoing, moving, living, breathing document. And when we look at this change that the Department of Labor recently released, is it all has come, again, out of, it's derived out of two different pieces. One is there is a class action lawsuit set forth by assistant managers at Walmart. They were out there and saying, wait a minute, we are required to work 60, 70, sometimes 80 hours a week for $11 an hour. And I think that was the average. Some made a little more, some made even a little less. But the attitude was they couldn't afford to live on $11 an hour, work all of those hours, and not live without, you know, WIC and, you know, live in Section 8 housing and all of these things, because when they're supporting a family and, you know, forget daycare costs at that rate, but you're making $22,000 a year ultimately. And so they came back and they won, and so they actually unclassified them and made them non-exempt from overtime. And then there was also, we're seeing a lot of things where other large systems, now McDonald's is a franchise system, but a lot of other people are coming back and saying, you know, I make nothing, can't afford a second job, and therefore, and required to work all these hours. So the thought process is that low-wage earners were being taken advantage of. And so they, you know, it's the Department of Labor's task they look at all the different pieces. And when they start to see things happen in many states and big cases like Walmart's class action, they then start moving the laws around to adjust. Now some of the original pieces of what we're talking about today were set forth in 1979. So that's an important component to consider, that things haven't changed since 1979. Again, the internet is not an employer's friend. It's a plaintiff attorney's friend, but it's not anybody else's. So when they went through and they made some changes, but they really only changed one component. They didn't change the duties test. There are essentially the basic exemption test, which applies to almost everything. And we're going to go through each of these tests individually, but there's the executive, administrative, professional, and outside sales, and a computer test. And the computer test obviously didn't come in 79. The computer test probably came in the mid-90s, early 2000s. So this is a constantly working, moving document. Again, back to that. So when we look at the basic salary test, this is what has changed. The basic test has changed, which is effective December 1, for someone to be exempt from overtime, meaning they don't have to be paid time and a half, they have to be paid $913 a week or $47,476. Now there's a little star there. That star comes in because of twofold. One is, unlike in 79 where they just established the $24,000 limit, they have changed that to, they changed it to where every 3 years it's going to be reviewed and adjusted. So it doesn't have to go through the process that this went through to make the change. Initially, it was thought it would go up every year with cost of living. Instead, to make it a little easier for folks, that it's changing every 3 years. The thought is by 2020, it will be $51,000 a year. So we're going to see growth in that. The other piece of that is that salary can you can pay 10% lower than that. However, if you can make it up in a guaranteed bonus. If someone doesn't make that bonus, then you have to go back and figure out all the hours that they worked and pay them out, all that overtime. So you want to make sure that you guarantee in writing that on a specific date, and it's legal to say, okay, if you know, for you to get your bonus, you need to be employed by February 15th when we do bonus checks for the previous year. It gets, the further you push that out, you can, you know, the further you push that out, the more challenging it becomes. But that bonuses is up to 10%, and that's the maximum. The other piece of that is employers, this is the other piece that changed. It used to be employees who made $100,000 and performed some exempt criteria, they automatically were exempt. That's not the case anymore. So you could have, say, a coder, a software coder, who you pay $75 an hour to. If they're, you know, they're running a group and stuff like that, they can, but that exemption test bumps them over. So you should be in good shape not to pay them overtime, but straight, you still have to pay them straight time. That's, you know, that's kind of some of that nuance in there. A lot of people say, oh, my office manager, my, you know, we'll talk about admins, but, you know, kind of my shift office manager, my group leader would fall under the executive test. And they've been pretty loose about this test in the past. However, we're finding when challenged, they are not loose about this test in the least. So it's kind of like you're fine until your employee reports you. And I want to talk about, just a side note on when you get reported. Your employee can report you behind, you know, anonymously. And so they are usually fine with whatever you decide to do until you end the relationship. And particularly if that relationship is not their choice, or even if they're tired and exhausted and they quit because of a million reasons, they still can come back and get you. So this is why I believe it's very important to look at this test. If you have people you pull under the executive test. Managing of the enterprise per the Department of Labor is defined as somebody who has the ability to walk into a local car dealership and lease a car within the company name. Their name is on the company checking account. They are truly managing your enterprise. And they must direct, this is a big thing, they have to direct the employees, 2 or more full-time employees, not for part-timers, not any of that. It has to be 2 or more full-time employees and at least working 30 hours a week. So they have to be able to do that. And the big thing is they have to truly be able to hire and fire. And you may say to me, oh, sure, they can hire and fire all they want. But the reality is that they have to come to you and say, yeah, I'm having problems with Cindy, and I think it's time we let her go, and I want to talk to you about it. And, you know, it's one thing if they're bouncing it off you, but if you say, yeah, Cindy is vital to the business and you can't let her go, then you're out of luck. They are not able to do this. And with any of these tests, I want to make sure you understand, it's not a, okay, they passed the salary threshold, so we're fine. You have to pass every single point of this. Colorado gets real direct in some of this, and again, gets testier when it comes to some of the state requirements in the executive test. They are very clear about managing the enterprise, and they are very clear that it has to hit all of these pieces, not, let's see, there's 1, 2, 3, 4 of them, not 3 out of 4, not 2 out of 4, it has to be all 4 out of 4. In every one of these cases, you have to meet every single piece. So you have to decide whether or not you're willing to put your manager on a company and part of that is, now granted you may say, well, wait a minute, Microsoft doesn't require that. You're right, Microsoft doesn't. However, Microsoft or any other large company may not have their managers on, but you're a small, most of you are small businesses. And if you do anything under $20 million plus a year, then that's when they're going to be looking. And another point to make on this, you may tell an auditor, oh yeah, they have access to all of this. They're not going to talk to you. They're going to talk to the employee, but they're really going to talk to all of your other employees and to ask, you know, what does Jenny do? Tell me about her role. Did she hire you? Has she ever terminated you? And things of that nature. And I also want to talk about, if you've never been audited, an auditor comes in and they're very nice. They're very, very friendly. They don't want you to take a fork and put it in their back when their back is turned. And plus, the reality is, nice people get more information from people. So you think they're asking you pretty basic questions and you're oversharing. Let me tell you about my business, because you have a passion and an excitement for your business. It's hard not to contain that. You wouldn't be self-employed and enjoy what you're doing if that wasn't the case. But in these kind of issues, these guys are, they're just in their mind, taking notes. That hurts you. So keep in mind, auditors are not our friends. Regardless of what they come in, you need to be nice and cordial. And I always, always, always advise that you have somebody sitting at the table. A shameless plug for my company. One of the components we do, because we sit through auditors, we actually formally hired an EEOC auditor. Her name is Amy Rupke. You can always look her up on our website. And Amy, she's based in South Denver by the Tech Center, and she goes all over the state and travels to other locations to sit with auditors and make sure that she's the bad guy and not somebody else. And again, shameless plug, but regardless of whether or not you have somebody sitting with you, you need to have somebody, and I do encourage you to have somebody, even if it isn't my Amy, you have somebody, not just your attorney, but you have somebody who's dealt with these kind of audits in the past. They know the auditors. They know what to expect, and you want to make sure that it's somebody, it isn't just your regular business attorney who, may be a little hoodwinked by these guys. We want somebody who's gone through this before and has quite a bit of experience in this area. So then, this is another one where we see a lot of problems in, and that's the administrative test. This is designed, if you have a small business, this is designed for the CEO's admin. They really, if you think about that CEO's admin, they direct, they may not have people working for them, but they have total control. And let me tell you from experience and trying to get in to speak to some CEOs, you can't get in and talk to them unless the admin, his admin allows you to get on their calendar. He either has to tell them, so you have to have already had contact with them, or, and they make big decisions on behalf of the CEO, which vendor is going to see them, what they're going to do, where they're going to go. So they have a lot of control over somebody who has such a finite amount of time that they make decisions for them. In my experience, no business that isn't essentially a Fortune 500 company has an employee who would meet the administrative test. There's the professional test. Again, they have to meet the salary threshold, but they have to have advanced intellectual knowledge. So, like my team, we're all exempt because we're all attorneys. But if it's attorneys, lawyers, a professional test would be a CPA. If you hire, your controller may not manage people, but they have a CPA license, that person would be exempt. So you might see some of those within, and it's somebody that sometimes you're bringing it in. It's a professional that you've used outside, and maybe you do need a controller to manage your books. Making sure it's not a bookkeeper. There's a difference between a bookkeeper and a controller. They would have the credentials, in this case, of a CPA, and so that's important to note. This is a big one that we've seen a lot thanks to Pfizer. Pfizer, the drug reps, Pfizer's drug reps a few years ago sued Pfizer because they were spending a fraction, most of their time. Drug reps, for those of you who've never been one or don't know much about them, drug reps are assigned a territory, a group of doctors, and they can come and go, and they have to drop so many samples off per day, and they kind of can set their own schedule. They schedule lunches with doctors, telling them about the drugs that they're dropping off, and do lunch and learns and stuff like that. So there's kind of that piece. Well, in Pfizer's case, people were spending 50+% of their time filling out paperwork that they were actually, they weren't storing the drugs in a storage locker, or they weren't storing the drugs and, giving them out to homeless people along their walk. They talked to, how many samples they left, and certainly for legitimate purposes. But they had them, it was for every per hour that they were spending with a physician, they were spending almost an hour and a half to 2 hours documenting everything that they had done. So this was created out of that, and this outside sales test pretty much was defined as this person can come into your office, fill out paperwork in your office or on the road following sales, but they can't spend more than 20% of their day doing administrative tasks. They need to be spending better than 80% knocking on doors and outside of meeting with clients and meeting with people. This is a big deal when it comes to telemarketers. They're inside salespeople, and so they do need to be, they are non-exempt employees and need to be paid time and a half anytime they work over 40 hours. Even if they, spend 50% of their time calling and making appointments on a regular basis. Now, granted, sometimes we see ebbs and flows, so, we would work with, through an audit, if that was ever questioned, we'd talk about how much was in, how much was out, and, maybe 2 weeks it's all out 100% and crazy busy for you guys, and then they get a week reprieve where they're in the office the whole week. And then we'd have to figure out the next 2 weeks they're out, and maybe they do 3 days. So they would look at that average, but roughly you need to make sure that someone is spending 80% of their time outside of the office selling your wares and what you do, your services, your widgets, your whatever. So they need to do the marketing in order to obtain orders or contracts for the services. So they don't automatically, your small businesses, and 9 times out of 10, it's not like McDonald's where you hang a shingle when somebody comes in. They have to be saying, hey, look at me over here, because chances are you have good competitors. And there's a reason that you're the best at it, and you want to make sure that they aren't going to your good competitors, that they're coming to you instead. This is one that was added, as I mentioned earlier, a little bit later, and that's this computer test. Passing the salary threshold is an absolute must, and for the most part, they have to be like, these are analysts, programmers, software engineers. They're skilled. They either have a bachelor's degree in software engineering, or they are, they have Cisco router certifications, Microsoft certification. They have to have advanced certifications. Now, because you and I both know that our children make us look like idiots when it comes to, I can't get this to work. I mean, that must come out of my mouth at least once a week. My 8-year-old can figure out things faster on the computer than I certainly can. And I'm not totally technology, but he may be my IT guy at times, but he hasn't even finished elementary school, let alone high school or any advanced training. So he would not, if he was an employee of my company and he was of age, of course, he would not be able to, until he has those certifications, he would not meet any of the computer tests. So then there's the nuance of, you may have somebody who comes in, and it may be your office manager, and they're on your, they have the ability to write checks, and they're on the accounts, and they have that ability. But they also, they may be out there doing, making phone calls for an outside salesperson, or answering phones and receptionist work and filing and things that would not do. You have to be very careful about how much of their job. And at least this is the one area that today, and I want to stress today, as of June 2nd, is in a gray area. And the gray area says that as long as they're doing 50% of their work as exempt, then the other part of that work, that non-exempt work, doesn't have to be can be exempt also. That's in the gray area. You certainly don't want to push it. If someone's doing 65, 70% of their day and non-exempt and they have the ability to write checks, that doesn't quite fix your problem. And so at that point, you don't want to be the person that people like me are talking about, because they have legislated it and it becomes the Microsoft Viscano case or something to that effect, a very popular case. So, and your competitors love when it's something about you to sell against you. So make sure you're trying to do your best to, when the work can be split, but make sure it doesn't exceed 50% of their work doesn't exceed 50% of their duties. So the one piece, when you do have somebody who maybe 70% of their time is spent exempt and 30% is non-exempt, you need to take and think about how you're going to calculate that overtime for them. And so you may pay them at different wages for non-exempt work, or maybe it's the same. And if it's the same, that makes it a little easier. But you have to figure what those, you have to take a weighted average. So for math, the math challenged like myself, I will try to talk you through overtime for an employee. So we have an employee who's working 60 hours, 30 of which of those hours are spent doing exempt work, and they're paid what essentially breaks out to be, for simple math, they're paid $10 an hour. And then for the other 30 hours that they're working, they get paid $15 an hour for the non-exempt work. Vice versa those. So 30 hours at $10 an hour, 30 hours at $15 an hour. When it comes to the overtime, we would average the $10 and the $15 at giving each an equal weight. So the average weight at that point would be, the middle is, for time and a half, base rate is $12.50 times 1.5%. Okay, so 12.5 times 1.5, making that hourly rate of overtime $18.75. So for the first 10 hours, if we said that the non-exempt rate was $15, you would pay them for the first 10 hours, because that's what they do to meet 40, would be $15. Then every hour after that, you'd pay them $18.75. I know that's it's kind of hard to follow without, I'm not, a math genius. So hopefully some of you are much better than I am in following my discussion. But consider that the time that you spend, you have to pay them the average wage between their exempt and non-exempt at time and a half, always. Even if however it works, if it's overtime, you would pay them $18.75 an hour. I'm sure we'll get questions, and my information is will be our final slide today. And so you do have the option to say, hey, this is what somebody's doing, and I can do some math for you. Sometimes it's easier to see it when you know exactly, have a good example. In some cases, some of you may have multiple locations, or you send your employees, say you have housekeepers, and you send your employees from, my house to somebody who's 10 minutes from my house and somebody who's 20 minutes from there, back to your office. Now, travel time, commute time is not counted as that work. So the ability for them to get from what essentially is their home to your office, that doesn't count. But once they are on your clock, if you pay them a percentage of maybe cleaning my house and cleaning somebody else's house and cleaning a third location, you have to pay them at least minimum wage for travel. between my house and the 10-minute house next door. You can look at some of that. My challenge becomes that we find with auditors is that if you pay in block rates, keep in mind those auditors do the math and they never do the math to their advantage. So if you don't pay somebody, you pay them like, oh, okay, at Carolyn's house it's $100 and so I give them 50 of that. You got to make sure that if they're there for 5 hours, they're getting $10 an hour kind of thing to cover you. Otherwise, you've got to make sure you do the math. The guy's going to be like, okay, you're paying them $10. They're there for 5 hours, $10 an hour. So in the next location, you need to pay her, $10 for the 10-minute commute kind of thing. They'll determine that. I urge you, if you're paying in flat rates like that, to consider moving towards an hourly rate to protect yourself, because you do have to include travel time. Now, you may call in a technical consultant to look at overtime. Consultants should be on hopefully they are a 1099, that they are a registered EIN number, and they're their own business, and you're paying business to business. But if you are hiring, your brother-in-law to come in and work for you, if he doesn't we go back to the tests, and if he doesn't, and he's a system administrator in his real job, maybe over at HP in Fort Collins, if he's doing that, then you're okay. But if he's not, you need to make, you're okay because he has those certifications, you wouldn't have to pay him any overtime. But unless you're paying him over the rate beyond, then you do need to consider the overtime, because the salary, boy, either I haven't had enough caffeine or something, my apologies. So make sure you're paying them at least the salary base to make them exempt. On-call time. Now, where on-call time becomes a little more tricky is it depends on what you allow them to do. If you allow somebody who's on call, they can just take the call from a phone on their hip or in their purse or whatever, and they can go down to Denver, then go visit, their grandchild in Colorado Springs, and as long as they can answer the phone and deal with whatever, you only have to pay them for the time that they're dealing with the work issue. If you require them to sit in front of a computer and the computer, it takes forever for it to load up and do all kinds of, your program, then you're going to have to consider whether or not they're totally free to roam. So if they are free to roam, you have the ability to let them fly, be free, be on call, do what they need to do, just pay them for the time that they're working. If they're strapped to multiple things and they really can't leave their house because they have to be on the computer to do 12 things once they get a phone call, then that becomes a problem. That means you have to pay them for their time. If they can't go down to Colorado Springs and be back quick enough for you, then you may have to pay them for their time that you can shrink that. Maybe you want to shrink it. They can be there in 20 minutes, but you can't require like you have to be able to be somewhere in 5 minutes kind of thing. I think you're really, it's gray. It's been litigated in Colorado. Some of that litigation we've seen, someone's been allowed, the furthest away is, or the closest we've seen is 20 minutes. I think that it will be challenged, and it's in the process of going in front of the Colorado Supreme Court. So I want to stress to you, again, if they can wander the mall, go to Fort Collins, go to Colorado Springs, you're in great shape as long as they can answer their phone. If they can't, then you have to pay them for all that time that they're waiting. Now, paid time off, jury duty, holiday pay, these are things, if they're earning their vacation, you offer PTO or vacation time, that doesn't, they may take 5 days and then have to do all kinds of work to come back. That doesn't count towards overtime. because they're doing some catch-up. You may want to take away, if they have to do that much work when they get back while they're out, you may want to give them back some of their vacation time. That's a decision for you. Jury duty in Colorado is somewhat vague, but the difference is by law, after the third day, you have to pay them $50 a day. If you don't count that $50 in standard pay, you're in great shape. Not a big deal. But if you start throwing that as their wage pay, then you have an issue. So you have to deal with your payroll provider or talk to whoever helps advise you on payroll to make sure that you don't classify that as actual hourly pay and just as jury duty pay. You want to make sure that it's well figured out so that if it's ever questioned, that's your base. And holiday pay, so, we just had Memorial Day on Monday. If somebody, if they get paid for Memorial Day, but then they work another 40 hours, it's, in my opinion, it's smart to give them a floating day if they have that much work that they can maybe use on another day, floating holiday, not floating, and pay them the full week's salary because they really didn't get the day off. But the law does not require you to do that, and they can still work 40 hours. You just have to look at what that does for the spirit and the culture that you're building in your office if you're going to require 40 hours plus give on top of a day off. Now, this is a big deal, comp time. A lot of people talk to me about comp time. The challenge with comp time you need to understand is that in compensated comp time saying, hey, I'll give you, I just said give you a floating holiday off, that's not comp time. You're paying somebody, you're changing the holiday, which you as a business owner have the right to do. However, you do not have the ability, if somebody wants to work 4 10-hour days and take Friday off, that's totally fine. But if they want to work 3 12-hour days, or they end up working 36 hours one week and the next week they work 44, you still have to pay, even though it's within those 2 weeks and together they equal 80 hours. The law looks at it in a standard work week. So you get to determine when your work week starts and when it ends, but within that work week of 40 hours that you've established, whether it's starting Monday morning at 12:01, ending at midnight on Sunday, or breaking your week Sunday to Saturday, however you choose to do it, you get to choose that. But once you're in that 7 consecutive days, if they work more than 40 hours, you have to pay them overtime. Now, there's some of you who may work for universities and government entities and things like that. They're exempt from this law. Also, if you work with unions, particular things, where they talk about, those can be separate from this. But unless you have an actual written agreement signed off by a judge, or you work for the state or the county, you can't use comp time. And we'll talk a little bit about other pieces. So I just mentioned that collective bargaining, your union, collective bargaining agreements, that's a little bit different. That's when things can be different. So what are your risks? We've talked a little bit about the audits. They're driven by complaint or just a routine audit. If you are not, we're finding in Colorado, if you're not doing the Colorado, oh my goodness, it just jumped out of my head, the Colorado, oh goodness, Colorado has their own version of the I-9. It'll come to me, probably tonight when I'm trying to fall asleep, it just escaped me. But if you're not doing the Colorado I-9, then and submitting that information to the state, they could randomly call you up and say, hey, wait a minute. And I've heard other people say to me, well, I haven't ever done it before. I don't want to get on anybody's radar because I've never done it before. They're not that equipped, but they'll start looking at, if you're a, $3 million business and you're only reporting on your income, you know, $150,000, they're going to go, excuse me, wait a minute, who else is doing the work? And why aren't you reporting their new hires? They pay attention to, they have algorithms that bump people like you out. They also, that's what's pulling a lot of people in the construction industry. But again, I talked already about how the internet is not our friend. When we look at what these fees are, back wages up to twice the amount of damages plus attorney's fees can be included in your liability. So let's look at just what, if you short pay a person $1 an hour, right, and they're working 40 hours, that would be $40 a week. Times 3 is $120 a week is what 1 hour, and that's before attorney's fees get added to it. So attorney's fees, when our friend, the strong arm, advertises, he goes through, he will negotiate deals with his clients. I'll take 10%, I'll take 20% of what you have, what we collect. But the reality is when he comes, the state comes to him and says, what are your attorney's fees? They're going to be 50%. So at $120, he will add $60 to that wage, so that $1 you've shorted somebody all of a sudden becomes $180 a week. And that's just for $1. And keep in mind all of the other things that come in. And then the other great news is if one employee reaches out to our friend, the strong arm, and you have 12 employees, all of a sudden the strong arm can represent every employee you have. So if you're doing it to one, he'll say you're probably doing it to others. You'll find your life in a subpoena hell and pulling you out. So that's one person at $180 a week. And then go back 3 years, sometimes 7, depending on what's going on. There's a big thing here. I starred personal liability. You can thank Enron for this. Enron established out of Houston that there can be personal liability for who are involved in compensation matters. So you need to consider that just because you're incorporated as an LLC, an S Corp, or a C Corp doesn't mean that they can't go after you, your home, your boat, your fun toys, and make you liquidate all of that in order to pay because you've made a financial decision regarding compensation. So that's something to always consider when it comes to that, that you could be held personally liable despite how you've set yourself up. So what are some things you can't do? An employee, even though they want to work for you, they can't sign a piece of paper that says, yep, that's okay, I don't need to be paid overtime. That's not their right to give up. You can't, and the state is well on the lookout for converting employees to contractors, so be very aware of that. Don't look at artificial rates of pay. Don't sit there and say, okay, I used to pay you a block fee, a flat fee, and that was $50 flat fee, you get that done in 2 hours, but now that I have to pay you overtime because you work more than 40 hours, I'm going to drop your fee back so that the time and a half that you work, you still get the same amount. That's the stuff that gets you in trouble, and people report that. I kind of talked about this already. Overtime is calculated based on a work week, not a 2-week period. So we talked about that with regard to comp time. So again, within a 7-day period, if they work over 40 hours, you have to pay them time and a half. Now, the other piece that I didn't hit on that's important to note in Colorado is, in Colorado, if they work, it's not just 40 hours in the work week. If they work more than 12 hours in a day, you have to pay them overtime. So if you have somebody who works 15 hours 2 days in a row, but that's all they work is 30 hours, you still have to pay them overtime. And that's a nuance that I'm kind of remiss in telling you until now. My apologies. So what can you do? What can you do? You have the opportunity, you can pay the wage increase, making sure that everybody meets the exemption tests. that we discussed already. You can hire additional employees. They don't have to be full-time. You can, you know, become a favorite, a place to work, and look at job sharing, where you have the same person sitting in the same chair, and one works half part-time. They may work 30 hours. The other person works 30 hours, and one works while her kids are in school, and the other one, the other one works in the evenings when she has somebody home to watch her kids. You got to figure out what that is. You can, look to that, but you can job share. You can always pay the overtime. Just, buckle up and, figure out how to do it, which I know is not easy. Or you can take the risk and just pay whatever penalties come your way. Those are certainly your options. There's nothing out there that says that you don't have to do something. So I'm going to talk about real quick, because I want to leave about 15 minutes. So start thinking about your questions and entering them in. But I want to make sure, because we have a hard stop at 1 o'clock. So when we look at something like a staffing coordinator, in a lot of home care agencies which we work with, the staffing coordinator has the ability, to some say, to hire and fire, and she's constantly moving people around. People call in and say, hi, I need someone to stay with my mom. She's not able to be by herself, and she has Alzheimer's. She schedules people, she gets them there, she hires, fires, gets them going. The reality is, the staffing coordinator, unless she has the ability to write paychecks, sign checks for employees, and truly has the ability to hire and fire, she would not be exempt. So that's something to consider. Your inside and outside account manager, aka salesperson. Your inside, we talked about. Inside is never exempt. And the outside, again, comes back to, if 80% of their day is spent outside with clients and things of that nature, then the 20% would be, then they would make it. Otherwise, they'd be non-exempt. We talked about the system administrator at length already. We talked about whether or not they qualify. So if your system has some Cisco router and some certifications regarding whatever the system requires, Microsoft, whatever, then you're in good shape. Otherwise, nope, they would be paid overtime. Your tricky assistant store manager. This is in a tougher area. Truly, you have to look at, when an auditor comes in, your assistant manager at a Home Depot is probably exempt. But if it's just, you're a husband-wife team and you own a store and you have an assistant manager below you and maybe one or two people below them, chances are, they look at it as a pyramid. You and your spouse probably own the business together. You're okay. But you would be the only ones that are exempt. So you've got to be aware of some of that, except for maybe a controller who's making sure, bills are being paid, and they, of course, as I said before, are your CPA. So it depends on the size of your store, the size of your business, as to determining whether or not that would count.
Thank you so much for your time and the presentation and the information provided here. I know that was great information that we'll be able to pass along to additional clients that come through the SBDC and provide them with some follow-up contact information.
I appreciate everyone coming today. Please feel free to email or call me specific questions, and I'm happy to help you figure it out.
Thanks again, and thank you, everybody, and enjoy the rest of your June 2nd.